can you explain some of the ways that the criminal justice system can cause secondary victimisation?
Well, secondary victimisation is colloquially called the second injury. So the first injury is that caused or resultant from the victimisation, in other words, the act of the perpetrator. And secondary victimisation is often understood as being the consequence of the act of someone who the victim expects to help them in some way, and that's not done. So, for example, a police person who doesn't treat a victim with respect, with compassion after a family member's been murdered, or a police officer who treats a victim of domestic violence with ambivalence, or even minimises the offending, or a police officer who doesn't fulfil his or her obligations as prescribed under the Victims of Crime Act. In terms of a prosecutor, the second injury could come about not only as a consequence of the actual behaviour and an attitude of the prosecutor, him or herself, but also the failure of that prosecutor to fulfil their obligations, such as on one case that I was involved with as a commissioner, a victim who lived 2.5 hours drive from Adelaide was invited to come to Adelaide for the purpose of consultation. When she arrived, the prosecutor said, "I'm not your lawyer and this is the decision I've made. What do you think about the decision?" And then after she rebuked the prosecutor and said, "Well, I thought I was coming here to be consulted and you were going to listen to me beforehand." They said, "Oh, well, we'll listen now, and if we think your argument's valid, we may reassess our situation." But then, while she was emotionally distraught by the way that she was treated and the behaviour, almost autocratic behaviour of the prosecutor, she was left to drive home in a highly distressed state for 2.5 hours. And when she spoke to me that evening, she said, "Where's the duty of care? For starters, here I am emotionally distraught and they don't even ask me if I'm okay." The second is that if they'd already made the decision, they could have just told me that over the telephone and saved me all the inconvenience, all the anxiety that built up in me to go. So she felt most aggrieved by it, and it magnified her sense of injustice that had been stimulated by the crime in the first place. The other areas that have been shown to cause secondary victimisation are the ordeal of cross-examination. A classic example that's often cited is that in a sexual assault, in order to prove that the intercourse happened, there only has to be the slightest penetration. But we've had children who have been anally penetrated, who've been subjected to cross-examination with, how far did it go in? How do you know it went that far in? If you were looking at the wall, how can you tell that it was the penis that was going up your back? So, like, all sorts of questions. We've even had a child have it suggested to her that the reason that she made up the accusation against the accused was so she could lodge a victim compensation claim. And this is a child who didn't even know what victim compensation was.
And they're so significant anyway, she probably get $2,000 or something.
Well, exactly. So the ordeal of cross-examination can be also a source of secondary victimisation. Justice delayed without adequate explanation, because some victims describe that as being in a lake where there is somewhere around the lake there is a shore, but you're just treading water while everyone else is getting on with their life, while you're waiting for someone to make a decision about what direction your case goes in. And so some people just get tired, they get weary, each time there's an adjournment, they've done the preparation ready to go to court, then they have this low, and so this sort of like being on a roller coaster can also be a source of secondary victimisation.
Is it also true that sometimes some victims of crime may delay therapeutic intervention because they're required to give evidence first and they don't want any indication that their evidence has been affected or tampered with through therapy and counselling and that kind of thing?
Well, there are some who don't seek treatment because they don't feel they need it,
Sure.
after the crime, but interestingly, they do seek it after they've been through the criminal justice system,
Right.
and which is part of that sort of magnification that the justice system does of the original incident. Or it may be that they've made a decision not to seek counselling because they don't want to suggest some sense of weakness on their part. And particularly men are less likely, in my experience, to seek any form of therapeutic intervention or even, in some cases, medical treatment for fear that they'll be perceived to have some weakness. There are some treatments that have been determined by some courts. So, for example, the New South Wales Supreme Court held out that if a person took hypnotherapy, then because while someone is hypnotised, they can be suggested different things to them that anyone who had hypnotherapy couldn't necessarily give evidence. And that carried over then because there was a bit of a misunderstanding of what EMDR, where people use their fingers and they do this sensory sort of style treatment. And there's some evidence to show that it's a very useful way of helping.
Is that an eye movement?
Yes, eye movement. By watching the people's fingers.
Right.
That's been, in the New South Wales judgment, it was so wide in its application that it suggested that even people who had that type of treatment may not be capable of giving evidence. And we've had a case here in South Australia where someone applied to have their matter reheard more than a decade later on the basis that they had discovered that at the time the victim gave evidence in the original trial, they were suffering from post-traumatic stress disorder. And some of the criteria for post-traumatic stress disorder would suggest that the person may not be a credible witness. And so they ran it. And if they had won the case, it would mean that
would be
a
huge.
significant proportion, not the mass, but a significant proportion of victims of sexual assaults would not be capable of giving evidence in court. So the reason I say significant proportion is that quite a number of people who are sexually assaulted, people talk about them suffering post-traumatic stress disorder, whereas in fact much of the research shows that they suffer depression or some form of adjustment disorder,
Yes.
and that post-traumatic stress disorder is lesser. But it seems to have become this umbrella under which we put all forms of mental health issues that victims of violent crime suffer. So I think there are a number of factors that, in the way that the criminal justice system is administered, that impact upon victims' decisions to seek treatment. But for me, and returning to what would one use the Victims of Crime Fund for? Well, governments, successive governments repeatedly talk about the availability of services. So at the moment we say we have a victim support service that's available statewide. True, but it's only Monday to Friday, 9 to 5. It might be available, but it's not necessarily accessible when victims want it, and it's not accessible to some of those victims' classes or groups that we know are more highly represented among victims, such as Indigenous women and children in very remote communities, or people from minority groups here, such as new arrival African and non-English speaking background, people where there are limited services. So that accessibility is also a consideration when it comes to whether or not victims who need help actually get help